Welcome everybody to our Art of Estate Planning Facebook Live for the 12th of September. So our topic today is mutual will agreements and are they worth the stigma? So today we are joined by a special guest who I don't think it's an understatement to describe him as Queensland estate planning royalty. We've got Bryan Mitchell from Mitchell Solicitor. Welcome, Bryan.
Thank you, Tara. That's very kind.
So for anyone in Queensland, you will know, Bryan has been the director of Mitchell Solicitors for, I think, coming up 25 years now. You'll know better than me, Bryan, but he is an accredited specialist in wills and estate, former chair of STEP Australia, I think former chair of the Queensland STEP branch, and in 2023 he was the recipient of the STEP Australia Masters Award. He's also a fellow of the Tax Institute and on the committee of the Queensland Law Society Succession Law Committee. So I think he is well qualified to talk to us on this topic today. And as you can see, he's been so generous with us today to share his knowledge and also generously contributing back to the estate planning profession. So it is an absolute honor to have Bryan with us. I will just be handing over to Bryan in a moment. I don't have a lot to contribute on this topic, mainly because my experience with mutual wills has largely been informed by the people who trained me, who wouldn't go near them with a 10-foot pole. When I was doing a little bit of research for this, I came across a paper from Robert Burgess from 1970, and some of the highlights from that paper include, a mutual will can be best be inconvenient and at worst little short of disastrous. And in these circumstances, the present writer would avoid mutual wills like the plague. So here we are to talk about, do mutual wills really deserve that reputation, or is there a role for them in modern estate planning? So I'll hand over to you now, Bryan. One more question. We do invite questions. This is a great opportunity to, explore mutual wills or defend your position if you are a mutual will advocate. So we invite comments in the commentary. I will be following that, but we will probably try and hold over most of the questions until the very end after Bryan has gone through his presentation. So over to you, Bryan.
Thanks, Tara. That's a lovely introduction. Welcome everyone. So this is a fairly topical sort of thing to get into. I remember the first time I presented on this, which was for STEP Queensland, I think back 2012 or 2011. We spent about half an hour after I presented debating on how you walk around these agreements when you're advising a client from an ethical point of view. So that was more of what we chatted about after the last time I did this. So don't know if that springs to mind for many of you. Okay, they've entered into it. How do I get out of it? So let's talk about it. Here's the opening scene. So firstly, we've got the Brisbane Kennedys, and so this is the case of Kennedy and Hunt and Griffiths. So this is a 2011 case. We've got Frank and Thelma Kennedy. They live in Brisbane, in Kenmore to be more exact. They married in 1947. Frank had a daughter, Barbara, from an earlier marriage, and she was raised with their two children, Bruce and Pamela. So there's three kids. So there's Barbara, Bruce, and Pamela. Frank died first in 1992. And when he died, both he and Thelma had mirror wills. So this is not unusual. So those of you who do a lot of estate planning for couples, they'll quite often have mirror wills, giving everything to one another, then to the three children equally. That's Barbara, Bruce, and Pamela. So what happened? Well, Frank died in 1992, and when he died, both he and Thelma had mirror wills, giving everything to one another, and that happened. Upon Frank's passing, Thelma, by way of survivorship, received the Kenmore home, so they owned it as joint tenants, okay? So she received it by way of survivorship. She also received some cash and some shares. Now, Thelma died in 2009, and her last will was signed in 2001. And we always discover this, don't we? Those of you that do litigation, it was a very different to the mirror wills she'd executed previously, whereby Pamela gets 1.5 million and the rest get 400,000 each. What happened, for crying out loud? Anyway, proceedings were brought by Bruce and Barbara. They thought this was a bit of the raw prawn. So in 2011, the matter was heard by, as she was then known, Her Honour Justice Anne Lyons. So evidence was put forward of an agreement. Now, a lot of these cases, and if you read the cases with equitable estoppel, a lot of them about conversations between the person who's saying, "Yeah, mate, this is what happened," with a person that can no longer give contrary evidence. They're dead. So it's pretty hard. And so it's so here we are. I'm just going to read this quote. And what I find, if you read these cases where evidence is put forward as to conversations that establish an agreement for mutual wills or establish the promise with equitable estoppel, the judge seems to want to believe you more if you, in your recollection, you have anchor points. And here's the anchor point. Bruce remembers being in the house of his dad and Thelma, and Thelma was at the sink. See, there's the anchor point. It was at the sink, and Elsa was nearby. Bruce gave evidence that at the point Frank called Thelma over, come over, right, and said, words to the effect, there's this agreement. So there's that example of an anchor point. And so the agreement was, and Bruce's evidence was, Thelma acknowledged and his dad acknowledged that there was this agreement between them about all to one another and then equally to the kids. So that evidence was accepted, and the agreement, in a sense, was upheld. So there you go, oral evidence of an oral agreement to do mutual wills. What are they? Well, we'll get to that. Wait, there's more. Let's talk about the Butterham couple. So, okay, we're going up the north coast now. So this is the case of Hussey and Bauer, which actually went to the Court of Appeal. So in this case, we've got Thelma Bauer. She was married to Bruce in 1967, and they lived in Butterham, up at the sunny coast. Now, Walter had 3 children of his first marriage, Bren, Rod, and Gay. And Thelma had 2 children of her first marriage, Carolyn and Helen. So 5 kids all up. Walter died first prior to his passing. He and Thelma had mirror wills. Here we go, mirror wills again, granting a certain life interest to one another and thereafter equally to all 5. So why was there a certain life interest? So there were mirror wills in that upon the death of both of them 5 ways, but Walter had a property solely in his name, and under his will, he granted, as well as other bits and pieces, he granted a life interest, not just a right to occupy, but a proper life interest in that to his wife. And she had a property solely in her name. She did the same thing, and then everything else to one another, and then upon the death of both of them to one another. So they actually identified property, and this becomes very important as well because there's identifiable property in the will. So Walter, what happened then? Well, as the saying goes, someone, you're talking to a succession lawyer, someone must have died. So it went to the Court of Appeal. At first instance, His Honour Justice Daubney, as he then was, found that there was enough evidence for a mutual agreement. So here, I'll just read this quote. This is really interesting. There was uncontested evidence that in or about 1989, so here we go, this historical evidence, Thelma visited each of the respondents and spoke to, so Thelma spoke to all of them, and there was evidence given that she said there's an agreement. She's the one that said it. She talked about the agreement with Walter, and so she told them all on or about this time about the agreement. So that was accepted, and there was lots of historical evidence about things happening in the past. And once again, if you read the case and if you get into this these equitable estoppel cases, there's always these anchor points. I was by the rose garden. I was in the shed. They're just things that cause people to remember. It was a lovely sunny day. It was raining cats and dogs. So the next one I will look at, the Victorians, and that's Birmingham and Renfrew. So this is the High Court decision. This is the leading case, and it's it's this is the one. If you do have an issue with mutual wills, before you read any, I should say, any of the lower court judgments, you should read this one. So this is Grace Russell and Joseph Russell, who was known as Jack. So Grace and Jack. And so they're a Victorian couple who made, once again, mirror wills in 1932. And under such wills, they made certain provisions for one another. And then, once again, here we go, equally among certain relatives of Grace. So they didn't have kids. Why was that the deal? Well, the deal was because the wife had all this family money she'd received, and really and the husband didn't really have much at all. So it was really, she thought, and he agreed, that it was quite fair that that should go back to her side of the family. But she was prepared on the condition he gets it all, so mirror wills, he gets it all, that the agreed to will would stay and it would go back to her relos upon him dropping off the twig. Now this is interesting because once again, these anchor points of memories. And so we've got evidence here. The only evidence which I need to refer to is below. Alexander Renfrew, so one of the husbands of the beneficiaries, tells how in 31 March 1932, he and his wife were with Mr. and Mrs. Russell in a motor car, I love that expression, on the way to the solicitor's office. So once again, this anchor point, we're on the way to the solicitor's office, we're in a taxi, we're in a cab, we're in a motor car, and we're going off to see the solicitor. And there's this conversation that they recall where I suppose Mrs. Russell, in a very forthright way, said, this is what she and Jack have agreed to. That's right, isn't it, Jack? Yes, that's what we've agreed to. So that was accepted as being an agreement for mutual wills. So if you want to, the last one I want to look at of these cases, and there's a lot we could read before we start jumping into the elements of the doctrine and what it's all about, was the case from which all of these cases are built, and it's a French one of Dufay and Pierre. So those of you that actually do French are probably just cringing at my attempt to pronounce that. So apologies unreservedly so given. So this is René Rank and his wife Camilla had come to England from probably France or Geneva. We're not really sure where they're from, but they did something called a joint will, yeah, and it was in French. So joint will, and it's in French. And once again, very similar to the High Court decision there, where they're granting a life interest in certain assets to one another, and then an agreed to, I suppose, because it's a joint will, an agreed to pathway as to whoever dies last as to these people that it goes to. And this is possibly the origins of the doctrine, where we've got the English court says, well, there's this agreement, and we're going to enforce it, and the last to die can't depart from it. And we're going to employ equity to give a remedy to make sure you don't depart from it. So that's really the start of the story. I should pause. I don't know if any of you have seen joint wills before. Those of you that are practicing, that were practicing in South Africa, I've seen my South African clients come to me with a joint will from South Africa. And so that's really interesting, isn't it? Which we'll discover when we're chatting through this, that your clients may already have, and you're about to do a fresh will, by the execution of that joint will, entered into an agreement for mutual wills. And your clients may already, you may need to direct your mind to whether or not they need to formally resile from that agreement. So there you go. So watch your South African clients. That could be a problem for you, especially if part of your due diligence is to ask for all previous wills. There's some. So I'm just looking at some of the questions here. I'm just going to pause. There's one here. I would have thought that a mutual will claim is a dispute in contracts. We'll get to that, everyone. That's if you look at that, that's the Victorian case of Flockus suggests that it's kind of like a silo case there. It's also followed by Midgelick. So the Victorians have gone in a certain direction, which is probably not reflective of the law nationally. And what were the other Timothy?
Just a bit of a chat about answering the question about is it a succession or contracts claim. And then Janice has said that she has seen a joint will that someone wanted her to just sign off on, which she said kindly no.
Yeah, look, Janice, wise, because let's think through that. I know we're going off topic a little, everyone, but firstly, it's possibly for the first. I've been thinking about this. For the first to die, it's compliant. You think of all the elements if you're a Queensland lawyer, and it's reflective around the country. Our Section 10 requirements. It's all there. You know, it's in writing. There's 2 witnesses. There's a bit of surplusage there where you're both signing it. So you're probably, even without going upstairs, you're going to get a grant of probate in the first instance. But where do you stand when the last one dies? It's you've got actually, in my mind, you've got a non-compliant instrument. So you're going to have to deal with that otherwise. And other than that, it's compliant under South African law or some other civil law jurisdiction, and it's not really in line with our law. But wait, there's more, which we'll discover as we talk through this. We're creating a problem that they may not be thinking through. They may have locked themselves up under the doctrine of mutual wills, which is a bit of a problem, I would have thought. So we've got these cases, and if you want to have a read of where the Victorians have gone with this, you can have a look at Midgelick, which is a recent case of 224, and Flockus. Now, in those cases, they're both one's they're dealing with the doctrine and what's necessary, and there's a focus on elements of common law contract in Flockus, as opposed to that's not what the High Court reflects. It's actually inequity and the remedies inequity. And there's also a discussion of the I suppose the statute of frauds applying in Flockus, and that's reinforced in Midgelick. Once again, I'm not sure that's the law nationally. It's certainly not what the High Court suggests, and it's certainly not. If you have a look at Forster, F-O-R-S-T-E-R, and Forster, even though that was a case not really, there was a formal agreement there. It's very scholarly, and it goes through and it kind of explains the different cases, why they're being decided in different ways in different jurisdictions. And so it's very helpful to have a look at that guy. Let's keep going. So in this paper, what are we going to look at? We're going to look at mutual will agreements, drafting the jolly things, if you want to do that, brave, very brave. Estate planning risks, estate administration risks. This risk word keeps on appearing, doesn't it, everyone? Estate litigation opportunities. Here we go. There's a positive in all of this, isn't there? And look, it's not me, it's you. We're going to talk about ethical and professional risks if we have time. Okay. And apologies, I was sharing with Tara. I've shared my random photos from a couple of months ago. Took the family to Tokyo. Had a great time. Eating street food and looking at random things. So this is one of my random photographs. So it's got about 4 parts, the mutual agreement. Okay, 4 parts. Just break it into 4 different parts. So part number 1, 2 people agree to make wills in particular terms. They don't have to be identical. And they further agree that those wills are irrevocable and shall remain unaltered. Okay, irrevocable and shall remain unaltered, or parts of them shall remain unaltered. Depends. Typical lawyer. Part 2, and I'm just gobsmacked. Maybe I haven't traveled enough that you can go into a 7-Eleven and just see that much opportunity. Anyway, part 2, one of the parties to this agreement dies, leaving the will in accordance with the agreement. So, okay, part 1, they agree to do wills in certain formats. They agree they're not going to change or revoke. Part 2, somebody dies. We're succession lawyers. Someone's always dying in our stories. Part 3, and that's in Tokyo Disney, by the way. We had to go there. My one of my daughters is just Disney crazy. I listen to Disney princess song after song every morning as I'm eating my cornflakes. So part 3, the last to die must not make gifts and settlements in a virus calculated to defeat the agreement. And you'll get that out of the High Court decision. You'll get some differences of views in some of the cases for different reasons that you can make gifts so long as they're not testamentary. But you must not make gifts and settlements in a virus calculated to defeat the agreement. And part B of that, in this part 3, you must bequeath his or her estate in line with the agreement. So the last to die must not try and defeat the agreement by gifting stuff out and must maintain the will, okay? You can't be half smart. Equity doesn't like people being half smart. And part 4, so I said there's 4 parts. That's a Japanese curry, by the way. If the last to die breaches his or her obligations, then equity will intervene, and the remedy being that of a constructive trust. So once again, constructive trust is not a cause of action. Constructive trust is a remedy. It's an equitable remedy. It is discretionary, and we'll talk more about that in a minute. So let's go deep. That's at the top of Skytree. So part 1 of the doctrine is there's 2 people, yeah, and they'd agreed to make a will in particular terms, and it's going to be, I suppose, irrevocable, and it's going to remain unaltered. So let's think about this word agree. Now, does that mean a formal contract? So perhaps I think we can. I don't think I have to get too caught up with this. Because the suggestion is by the academic writers, it's a loose term. You know, it doesn't have to be a formal contract. It can be oral. And I just gave you a smattering of cases, and there are plenty more, I must say, where it's kind of like they don't agree to much, and the court implies everything else. You know, it just implies every other term. So it's an understanding, an intention to execute. You know, it's Julie Cassidy. She wrote a little book. I don't know if any of you read it. It's published about 2000, probably getting a bit long in the tooth, where it's on mutual wills. And in that book, she refers to it as an agreement, understanding, a promise or agreement, undertaking. And so that's all taken from the High Court decision too. It doesn't necessarily have to fit all the elements of a contract. Curiously, all the reported cases do, by the way. And there's, you know, does it have to be in writing? And so there's a lot of discussion, and it doesn't. It doesn't have to be in writing. If you look at all the reported decisions, the only thing that's in writing is the will. But if you look at the High Court decision, they couldn't even find the agreed to will, for crying out loud. And yet it was held to have been in existence at some stage. So in you know, there was oh sorry, that's my apologies, not the High Court decision. That's Kennedy and Griffiths, where there was the terms of the agreement were proved, but no one could find the will, and still that got up. So that's really interesting. Does it have to be in writing? Now, if you look at the Victorian decisions of Flockus and also Midgelick, the recent one, there's some discussion on statute of frauds applying, and so saying, yeah, it applies, but this is an exception to it, and I'm not sure. It's you know, it's like arguing as to how many angels are on the end of a needle. I'm not sure it's that relevant, because in Flockus they found that even though it applies, this would be an exception, whilst the balance of academic opinion is it doesn't even apply. So I don't think anything turns on that, folks. It has to be sufficiently certain. Like, you know, when you talk about certainty, when you're dealing with a husband and wife, a couple, you know, it's not like we're dealing with commercial contractors where every jot and every tittle, but it does have to be sufficiently certain to have some degree of enforceability. Now, we know that, and they intend to be legally binding. So, you know, there's a whole stack of times that people agree to something, like we agree to go to dinner. It doesn't mean we're it's not like an enforceable contract. I'm going to sue you. You didn't come to dinner with me. So you got to be careful about what you mean by that word agree. So it's a bit hard there. So let's have a look at if I go on that page. Oh, consideration. Okay. So we're going to look at there's got to be consideration. Now, this is once again that's usually found to be the case. Now, when you look at if it's founded in contract, common law contract, then it's an essential term. Some of the academic writers suggest that it's founded in equity and therefore consideration is not required. I put that forward as an idea about 10 years ago, and I got a personal phone call from Professor Lee who said to me, now, Bryan, that's not right at law. Even in equity, there must be consideration. So I'm contrite. I stand corrected. There must be consideration. Having said that, the mutual promises are the consideration. So, it's got to be irrevocable. But hang on a tick. A will in itself is revocable. So what does that mean? Well, okay, we understand that, but you agree that you're not going to change it. And there's the act of marriage. That's revocable too. That will cause the will to be revoked. So where does that sit? How do you deal with that? So it's a little tricky, isn't it? So I'll just get into that. When you're property caught by the agreement, so that a lot of the cases you'll see where that you think, okay, this person, there's a Western Australian case where they did a transfer of property out of their name to a discretionary trust, and that was held to be outside the terms of the agreed to the mutual will agreement. But that was a case where, if you look at the other cases, there's actually identification of specific property. And so that's the difference, I suppose, if you're going to harmonise all these cases and not suggest our federation is going in different directions. So you've got to identify the property caught by the agreement. And it's easy to identify that, like if you look at the more recent cases in Queensland, where there's actually this, or even in the French couple, where there's a life interest for real property, and we're actually identifying the property in question. So if that property is identified, and we start to say, oh, I'm going to transfer that out, then you're probably, no matter how you do it, you're probably taking a step to defeat the agreement. So what's the burden of proof? Look, there's a lot of conversations, a lot of energy spent in these cases, particularly with equitable estoppel cases about the Briginshaw test and all that. But at the end of the day, it's what I get a sense from all of these judgments, particularly with mutual agreements that go back a long, long way, is it's a balance of probabilities. But you, as a judge, be very, very careful. Be very, very careful, is what I get. And you want to have clear and satisfactory evidence. Part 2, where one of the parties to the agreement dies, leaving a will in accordance with the agreement. So the doctrine's not confined to where the surviving testator benefits. So I know I was fascinated by the Baudets, forgive me. So it's even if you disclaim, yeah, I noticed that Mitchell one was on appeal. It's watch this space. If it's even if you disclaim, so you're the last one to die and you go, yeah, I don't want it, I'm disclaiming, you can't be half smart once again, you're still bound by the agreement. So it won't prevent an action by a third party enforcing it. Part 3, must not make gifts and settlements in advisors calculated to defeat the agreement. So this is interesting in that you've got, I'll just get the name of the case for those of you that are interested. Where is it here? I've got it here in front of me. There it is. It's Constantino, that's Cosentino, 2010, Western Australian Supreme Court 40. So in that case, it was held that the gift out of the last to die's name to a discretionary trust was outside the agreement. That was not a case where the agreed to wills were identifying specific property. So that can be explained away from all the other reported decisions. If you look at both Queensland cases, attempted transfers out of your name will be restrained if people get wind of it. So I think if you know what's in and what could be implied and what could not be implied, this probably informs you as to the vagaries of litigation as to if you're going to do a formal agreement, what you should have in. So you shouldn't be giving out. So part 3 of the doctrine is that you're not to make gifts and settlements in a vivus calculated to defeat the agreement. And part B is you must bequeath your estate in line with the agreement. So inter vivus gifts and settlements, how far can you go? The WA decision suggests, in line with a previous High Court decision, which was about a contract to do a will, where property was placed in the person agreed to do a will providing for a certain person, but maintained a joint bank account with another person. And that joint bank account, of course, goes by way of survivorship, and that was held to be outside of the agreed to will. And that was not testamentary in nature, and so that was the exception. So once again, if you're going to draft these things, you've got to be aware of this, that what's in, what's out. It's pretty scary. Okay, part 4 of the doctrine, that's up on a hill somewhere, I can't remember where, of the doctrine is the last to die breaches his or her obligations, and they can either do that by trying to transfer stuff out while they're alive and someone gets wind of that, or they die with a will not in line with the agreement. Equity will intervene. Now the doctrine, there's all this conversation, there's beautiful language, of a floating trust, kind of like one person passes as per the agreed to will, and there's this floating trust, constructive trust, which will crystallize when the last to die. But if we look at Foster's case, which is a recent Queensland one, which does a full analysis as to when this jolly trust exists, it's just a very helpful reminder that here we are, we're dealing with equitable remedies, and where all this sits is in equitable fraud. Okay, same with equitable estoppel. It's equitable fraud, and this a constructive trust is a remedy. It's part of the toolkit. So you don't know you've got one until the court says, "I'm going to give you one because old mate over there's been naughty." So in Foster's case, if you want to have a read of that, the first person died, last person survived, and there was no dispute as to the terms of the mutual agreement. The beneficiaries of the agreed to will, one of them in particular, wanted disclosure from the spouse of the surviving spouse, saying, tell us what's in, tell us what's out. We want weekly report, not weekly. We want yearly reports, because you, my friend, are the trustee of a constructive trust, and you have obligations as a trustee to share the terms of trust and information with us. Now, the court spent a lot of energy saying, essentially, this is the Bryan Mitchell Reader's Digest version, the constructive trust is a remedy. It's a remedy. And it's only, unless you got wind that the last to die is being naughty or is about to be naughty, then the remedy, you can't call for the remedy, therefore you can't get transparency. So unfortunately, the applicants there were unsuccessful, and it's probably wise that didn't go on appeal. Because I can't see the court, if you look at the High Court decision, it's remedial. It's equitable fraud. So it's not like if you think of a resulting trust is always there, the presumption of a resulting trust, as opposed to a constructive trust. It's only there if the judge says, yeah, I think you need one of these. The old mate over here is naughty. I'm going to dust this off and give it to you. So off you go. So how to identify mutual will? So let's do some myth busting, everyone. It's always good. Bloodline trust provide asset protection. Myth number 1. No, we're not talking about that. Mirror wills. Mirror wills are code for agreements for mutual will. Just because there's a mere simultaneous execution of corresponding wills is not sufficient to establish mutual wills. Pause. I think I'm pretty comfortable that if you're executing a joint will, that in itself, the joint will, that in itself is evidence of an agreement for mutual wills, and it would be implied that there's this agreement, that there's an agreement not to revoke that little fella. Okay. Dixon in Justice Dixon in Birmingham and Renfrew, that's the High Court decision, that many couples may agree to do wills, but does not mean they're entering into mutual will agreements. So there you have it. So just because there's a mirror will, you might smell a rat that there could be one if you're administering an estate, but you need probably a little bit more. And I draw your attention to Dufau and Piera, where there was a joint will, and we talked about at the start of this meeting that South African, I've seen a few joint South African wills, and I have actually got my clients to formally resolve from the said agreement so that they, the last to die can maintain testamentary freedom, which is what both of them want. And you've got the case of Fernando and Maskey, which also involved a joint will, and so that was held to the doctrine to apply. Okay, so drafting them, pause. You've decided you're going to draft them. Why? So you've got the warnings. You've got the warnings from Tara there at the start, and I think there, you know, there's, you know, there should be. I'm not suggesting it's got a big no smoking sign or no mutual will sign with a big cross through it, but be very, very, very careful. I've raced through the doctrine. I do have a paper. I was reading through my paper, and it needs a lot of updating, but I'm happy to make it available once I've finished to those that of you that are interested. If you just send me an email once I've finished updating it. It's a beefy doctrine. You've got to be very, very careful if you want to draft these things. You want to understand the doctrine very deeply. You'd want to, the cases that I've referred to in that slide, you'd want to have read those and thought deeply about them. Particularly, I don't know if any of you have been involved in estate litigation involving mutual agreements. It's very uncertain. It's very uncertain. So it's and if you're going to do a formal agreement, then there's a lot of uncertainty. So why on earth would you do it? Okay, let's hear me out. I'm going to be a devil's advocate. I have drafted these. I've drafted several of them. Why would you do it? Well, because I want to. No. So it's superannuation. Let's park on superannuation. So the clients might be a blended relationship. Hear me out. They come to you and they say, I want to put my $1.1 million super to my adult children. And you tell them how much tax that is, and they go, oh dear Lord. And they're not at preservation age. They go, oh dear Lord, I don't really want to give that much money to the commissioner. You know, I love my great country, Australia. It's a beautiful federation, but I truly don't want to give close to 160,000 in tax to the Commission of Taxation in that circumstance. You know, in excess of that. Sorry, I can't do sums in my head. So they go, okay, I don't want to do that. I want to give it to you, darling. Darling, I want to give it to you as well. Okay, that's great. And so that might be an example where they dislike the commissioner so much. Sorry, commissioner, that they want to give it to one another, but on the understanding that that quantum is going to go to I don't know, the children of the first to die upon the last to die dying. And you go, well, that's a heavy premium to pay to save, you know, over 100,000 in tax. There's probably other strategies you could engage to avoid that, but that could be a reason. I don't know. I'm just making this up. What's another reason? It might be a modest estate. And Tara and I were just chatting a little bit about this at the start of this meeting here. It might be you've got clients that are very advanced in years. Once again, blended relationship, dysfunctional on both sides. So they've got a modest home that they own as joint tenants. Yeah. And they haven't got much else. They've got a little bit in the bank. They've exhausted their super, so they're dirt poor, and they want to give peace of mind to the survivor, but they also want to make sure. So that's why it's maintain the joint tenancy. And those of you that are in New South Wales, I know that's not perfect because we've got notional estate. We could rip that in half anyway, but hear me out. So they want to leave the joint tenancy intact, give it all to the other person. They don't want to sever the joint tenancy. They just want to leave it intact and give it to the survivor, so that if the survivor needs aged care, it can be sold and pay the RAD. They're being very considerate because it's a very modest estate. They don't want upon the first to die, they don't want anything to form part of the estate. But they also don't want the last to die to rip off, for want of a better phrase, the children of the first to die. So they might enter into a formal mutual will agreement. And they're not perfect, are they, everyone? When you think about it, we know from other decisions that they won't. If you look at Barnes and Barnes, where it's a contract to do wills, I think that's 2003, High Court of Australia, everyone. Could be 2005, I get my prime numbers confused. Where that won't take assets, certainly under the South Australian legislation, and they're very similarly phrased around the country, that won't take assets out of the estate for a family provision claim. So it's not perfect there. It's not perfect because it won't, the last to die owns those assets, so it's not going to take away assets and stop someone having a crack at you if you fall out of love with a new spouse. But it doesn't have to be poo-pooed completely. If it might be part of the toolkit, but not the sole toolkit, that's to be considered. So some of the solutions in dealing with blended relationships, if we dust off all of those, is that could be what are the the direct provision. It's a very healthy estate, and we can afford not to give the spouse everything, and still the spouse will have a very wonderful and full life. Thank you very much. So we don't have to give the surviving spouse everything. So if the estate is big enough to achieve that, keep everyone happy, then Bob's your uncle. If it's a modest estate, we might consider everything old is new again, a flexible right to reside, to make sure that that half share is not going to form part of the property of the last to die. Once again, to speak to that concern about them shacking up and that being the subject of an I don't love you anymore sort of claim, or heaven forbid, a family provision claim from this new mythical creature called the new spouse. So or you might want to consider the utilisation. And this is not, of existing trust in a Vivus trust, changing ownership, and certainly a careful consideration of the utilisation of trusts under the will of various forms that may or may not achieve the result you think they're going to achieve. But the big idea is that it may be part of the solution, but not the entire solution. So let's have a look at our checklist. If we're going to have a crack at these things, that's a samurai uniform, everyone, and that's his little whiskers there. So if you're a young one, or no one can tell your gender if you're fighting in the field there. So that's very clever, isn't it? So what do you want to do? I suggest you would put them, if you're going to do it, you would put it under seal, everyone. And I would use your recitals, utilizing ideas of common law estoppel. You can use your recitals to create an agreed to factual matrix that is helpful to the parties. You want to identify the property that you're dealing with, either as being particular forms of property and excluding other things, or perhaps it's a value that you're agreeing to. You might say, well, the agreement is we take a snapshot of the value of the estate when the first person dies, and whatever that value is, the agreement you're bound by to make sure you do X, Y, Z for 70% of the value of that. And right, we agree to that. The agreement may set out that you can't be half smart with superannuation nominations, that you're going to make sure that your nomination is in favour of your spouse. You would deal with remarriage. You would have a clause in there that suggests that the parties are bound if they intend, the last to die intends to marry, that they're going to do a will in contemplation of marriage or do a fresh will. You would have a specific clause there because of the ambiguity in the law nationally that you will not deal with, and define that broadly, property so as to defeat the agreement. And you'd consider other anti-avoidance. You would want to think about excluding certain assets. You would want to make it clear that the last to die can't be a half smart, and suggest that disclaimer has no effect. What you want to do is not have them locked into agreeing to provide for their own kids. You don't care about that, so they're non-essential parts. If the last to die wants to disinherit their own kids, for crying out loud, let them do that. So you would exclude that from part of the agreement. You'd want to have your will being thoughtfully drafted, a whole series of what ifs. I would suggest you want to think through enforcement. It is enforced. The remedy is an equitable remedy, but how does anyone know? Like marketing, how does anyone know unless someone tells them about the world's greatest mousetrap? And strongly consider having a notice to beneficiaries clause and how that can be done so people actually know about this jolly thing. And if you look at Foster's case where the last to die, the kids of the last to die smelt a rat, perhaps it would be a fair thing to have that the last to die is obliged to provide information in a certain format to the agreed to beneficiaries from time to time. Maybe that would cause them to be at ease, so that there's some of the things you might want to have in your checklist. So what are the advantages versus the disadvantages? So a lot of these cases, if you read them, like if you look at Flocker's case where it was explored about life interests and so forth, but and certainly Mitchell was explored as well, that life interests and so forth, but where it landed with their negotiations as a couple was that I want full use and freedom of ownership. So that's the advantage really. You own it. You can deal with it. You can sell the house, buy another house. You're not limited in your usage of the assets. So that's one of the advantages. Another advantage, if they're drafted in a thoughtful way, will rein in assets outside of the will. You can rein in superannuation with the agreement. You can rein in joint assets that flow to the survivor and give enforcement rights teeth in that regard. C, and this is what Tara, you and I were chatting about this at the start, and that is all these reported cases, if you look at them, where we're fighting about the existence of the agreement, the lawyer doesn't know about it. The lawyer who prepared the will had no idea that there was a mutual agreement, and yet there was. And so what you might be doing is giving certainty to an agreement that is already in place. You may avert family provision claims. If people know, this is all academic, obviously it can't stop a mutual agreement, a family provision claim, but if people know that there's an agreed to will and the will maker is bound to provide for them, that might cause them to be a little bit more reflective about bringing a family provision claim. And look, it might also give rights to beneficiaries that don't have standing as family provision applicants as well. So you might be, so these are all, I'm being positive here. This is the glass is half full sort of Bryan at the moment. Bryan's going to turn negative in a millisecond. And that last point, G, and I talked about the advanced years clients, modest estate, don't want there to be everyone fighting at 60 paces and dissipating the estate, so everyone's a loser. There's not even enough to live and pay the RAD, and it might be the only solution, just quietly, to actually have a chance of the kids of the first to die to get something with such a modest estate when you've got a relationship of a gazillion years, so they'd gazump any applicant with a family provision claim. So it might be the only solution. 2003. Thank you, Tara. So that was the right prime number. Okay, so what are the disadvantages? And they are many, and this is where we should pause and think deeply about these things. They're inflexible. So I would never recommend that couples who are young-ish and consider entering into these. Now, I have a sliding scale of young. And so as I get older, anyone 5 years younger than me or even 5 years older than me, I refer to them as young. So if I keep practicing When I'm 80, I suppose I'll refer to 70-year-olds as being young. So it's a relative thing, and it's all about, the big idea is they're inflexible. Uh, they're limiting that surviving spouse. If there could be a huge delay for the ultimate beneficiaries to receive their inheritance. That's that. But that's the same negative, I should say, as well, of giving the spouse everything and not giving the kids anything, particularly for blended relationships. Because if the last to die is blessed/cursed with longevity, then they're waiting a long, long time. You're creating a de facto life interest without all the protections. A life interest would, or some sort of discretionary, some other trust arrangement might actually be better. How to identify the property may be quite complex. It's the subject of the agreement. You might actually, and this happens, I see this with people that have wills with trusts. It creates a false sense of security. Like I had someone the other day that said to me, I've got this U-Butte trust in my will. That means my kids can't sell the property. I said, that's not true. They could just sell it tomorrow. But same with these mutual agreements. We might be giving a false sense of security. They may not avert a family provision claim, and they certainly won't stop a family provision claim. It requires clear and considered drafting, and it might be way too inflexible for young people. And maybe the subject, there could be a problem. There'll be a big legal argument if they marry and it revokes, and they don't avoid the rights of the new spouse, both alive, I fall out of love, and also the new spouse bringing a family provision claim. And here's the last one. Don't want to poke the bear too much here, but it may leave one or more of us for claims of negligence. So that's an Owl Cafe I went to. Enforcement, who can enforce it? Those parties who are from the last to die. It's an equitable claim. The remedy is a constructive trust. So a will is a revocable instrument. So say the last to die was naughty and you would seek a grant of probate on that will. However, the remedy in the court would be the entire estate would be held on trust under the terms of the agreed to will. So I just want to jump into some estate planning risks and then some estate administration risks. I think one of the estate planning risks we have, folks, is failing to identify their existence and failing to provide advice to the clients that it is an option. And I'm sure everyone has a different practice. You get two lawyers in a room, you get three opinions. For the times that I am doing mirror wills for clients, I'm making sure we have a reflective term in both wills, making it very clear in very plain language that there absolutely is no mutual agreement, that each party has full testamentary freedom, and there's a mutual recognition of that. And sometimes that brings up, even though you've spoken about this ad nauseum, that brings up a further discussion. They go, no, that's not the deal. And you pause and you talk it through, and you may be able to act in drafting it, or you may have to lawyer up at 50 paces. So in checklists and making wills, to make sure that we don't accidentally ignore the existence of a mutual agreement, we'd want to retrieve, this is what we should be doing. This is the gold standard. We want to retrieve all previous wills and agreements and current agreements. We want to talk about testamentary freedom, and I talked about a mutual disclaimer. Okay, the same with estate administration. We just want to be cautious about this, and perhaps as a matter of procedure, even when it's a jolly simple administration, we should be retrieving the will file and asking the executor questions. So there's obviously, I'll finish in a millisecond, there's a lot of opportunities out there for us to explore of where there might be an agreement. It might be as vague as blazes, but it might be an agreement, and we'll find that out through asking and looking at notes, and there could be opportunities to enforce rights. Okay, so I've got, I don't have time to go through this. I think I covered all of this before. The risks of drafting these things for a couple. You'd probably want to have, which I didn't cover previously, you'd want to have a clause that they can, while both are alive and both have testamentary freedom, testamentary capacity to exit the agreement by notice to the other. Okay, so Tara asked me to finish at 5:2. It is now 5:2.
Oh,
If
you
anyone,
nailed it, Bryan. Thank you so much. And we've had a lot of questions. So
oh,
I've been putting them in the side in our chat here, and I think we've answered nearly all of them except perhaps two.
okay, let's have a
So
look at those. Yeah.
Timothy asked, given the long-term implications, would you generally involve counsel when settling the terms of a mutual will agreement?
Timothy, that's a great question. I personally wouldn't. I just draft it myself. If I was to involve counsel, I'd want to make sure it's someone that's familiar with the doctrine and has possibly been involved with it to assist you settling it. So I don't see that as a problem. You just have to be aware it's a broad church of experience and skills, and you just want to make sure you're briefing a succession type barrister that's familiar with this doctrine.
Bryan,
Kimberly Martin.
Janice asked if there's time, and maybe we don't, maybe this is too big a topic, but
Yeah.
your thoughts on the New South Wales, like notional estate defeating a mutual will?
It's okay. So it's will notional estate defeat? Well, notional estate it's not so much going to defeat the mutual will agreement. It may make because it's just a tool of a family provision claim. I think in your mutual agreement, you'd want to make sure that you don't allow people to be able to double dip, that if they have a crack at the estate of the first to die, and they could do that, that there's a clause in there whereby the second to die has the ability to abate their obligation for that amount to provide for for that person that had a crack in the first to die. The mutual agreement is all about what is in your name when you die and how you deal with it in your will. So, if anything, the big idea is a family provision claim may fiddle with that, which is regrettable. So once again, that's feeding into that big idea. They ain't perfect, unfortunately.
Thanks, Bryan. And probably this is our last question from Kimberly, which I've put here. What are your views on including nominees, so perhaps each party's chosen beneficiaries, who can provide consent to changes to the arrangements under the mutual agreement after
Yeah.
the death or incapacity of one of the parties?
Yes. Well, I certainly thanks, Kimberly. I certainly draft that in my document. You want to be very thoughtful in dealing with that. I think it's a great idea, but once again, one would argue it's Kimberly, it's a power. So think about the common law dealing with powers. Is it a power jointly held? The common law with that is a power jointly held. One person dies or loses capacity. The power is suspended, so no one can consent. So you'd want to think through how you draft the said consent there and deal with incapacity and death of one or more of those consenters.
Well, thank you, Bryan. I think we might wrap it up there. We're just getting comments coming through just to say thank you so much for a insightful and generous presentation. I'm sure we've learned a lot, and this will be a great resource for us all to be able to keep coming back to and refresh ourselves when we are presented with a client scenario that involves mutual will or potential mutual will. So on behalf of everyone, I just want to say thank you so much. You've been so generous, and
Thank you,
this is,
Tara.
yeah, we really appreciate you coming on and sharing your knowledge with us. Well, we'll wrap it up there, everyone. Thank you so much to everyone who's joined us live as well. I always love the discussion and the lively debate when we are live. Bryan is in our Facebook group now. So if you are watching this as a replay, you can just tag him and myself, and we can keep that conversation going as well. Thanks, everyone. See you next month.
Thank you.